Our purpose in this video is to explain the exact meaning of Taqlid as it is understood by the jurists. This will be followed by the meaning of Taqlid in other legal systems and in life in general. Finally, we will identify certain violations of the doctrine of Taqlid in the modern age. The word Taqlid is derived from Qalaadah, which means an ornament or neckband tied around the neck like a necklace, or it is the strap that holds the sheath of the sword and is usually swung around the shoulders. The word Qalaadah is also used to mean the strap by which a piece of wood is hung from the neck of an animal. It prevents the animal from running astray because it strikes it on the knees when it tries to run. In this sense, the word Taqlid carries a restriction within it, and this restriction is found in the technical meaning of the term. In its technical sense, Taqlid is defined by Ibn al-Hajj as acting upon the word of another without hujjah or proof. There are two ways in which this definition has been understood and has led to some confusion about the meaning and role of Taqlid in the present times. The first meaning is assigned by modern writers. Abdur Rahim, for example, understands it to mean the following of the opinion of another without seeking knowledge of the basis for such opinion. In other words, when a person asks a jurist for an opinion, he should not ask him about the basis for his opinion, whether it has been derived from the Quran, the Sunnah or Ijma, or some other source. He should follow it without question. This meaning is generally accepted by most modern writers, and it is this form that they condemn. The implication of this explanation is that not following or not observing Taqlid should mean that the layman must always ask the jurist about the basis of his opinion, whether it is based on the Quran, or the Sunnah, or consensus Ijma, or on one of the rational principles. Is this justified? Does the layman have the ability to comprehend what the jurist will say? The implication is ludicrous, if nothing more. Another implication may be that one who considers himself an expert should not follow this jurist. The response to this is that the expert is not restricted in any way from deriving the law through his own interpretation. The question that may arise is whether he is really an expert and what conditions need to be met before he can undertake such interpretation. The full response to this requires separate treatment under the topic, "Why is following a single school obligatory?" We will elaborate on this topic in a separate video. The earlier jurists did not understand the meaning of the definition of Taqlid in this way. According to the jurists, the word hujjah means proof or lawful authority, that is, permission given by the Sharia. Prohibited Taqlid, therefore, means following the opinion of another when the Sharia has not given permission to do so. For example, the Sharia may not grant permission for Taqlid in the tenets of faith. This lack of permission makes Taqlid unlawful. That is, whoever follows the opinion of another without permission of the Sharia is committing an unlawful act. Following the opinion of a jurist, however, does not fall within this meaning of unlawful Taqlid. Muslim jurists maintain that following the opinion of a qualified jurist is permitted by the Sharia and is not unlawful Taqlid. This means that there are two types of Taqlid: prohibited Taqlid and permitted Taqlid. To understand this thoroughly, the hukum of Ijtihad as well as that of Taqlid needs to be examined. To understand the meaning of Taqlid in law, let us examine the definition again. According to the jurists, the use of the word hujjat in the definition, acting upon the word of another without hujjah, excludes such activity from the meaning of permitted Taqlid. If, however, a hujjah or proof is present, Taqlid will become permitted Taqlid. To understand the meaning of permitted Taqlid, al-Shawkani explains that the use of the word hujjah excludes the following four types of activity from the meaning of prohibited Taqlid. Acting upon the words of the Prophet, peace be upon him, is not prohibited Taqlid. Acting upon ijma is not prohibited Taqlid. Acceptance of the word of an upright, adl, witnessed by the qadi, is not prohibited Taqlid. The layman acting upon the word of a qualified jurist is not prohibited Taqlid. The Hanafi jurist may add a fifth case to this. Acting upon the opinion of a companion of the Prophet, peace be upon him, is not prohibited taqlid. These cases do not fall under condemned or prohibited taqlid because the Sharia has permitted all these forms. A hujjah or proof exists for such permission. Some of these cases are obvious, but the case of the faqih or jurist is explained by Imam al-Ghazali as follows. If it is said that you have condemned taqlid, and the layman's taqlid of the jurist is the very essence of taqlid, we shall respond that taqlid is the acceptance of an opinion without hujjah, but following the opinion of the mufti has been made obligatory or wajib for the layman through the evidence of ijma, just as it is obligatory for the judge to accept the statement of an adil witness. Thus, the authority permitting this activity and excluding it from the meaning of prohibited taqlid is ijma. Following the opinion of the jurist by the layman, therefore, cannot be called prohibited taqlid, that is, condemned taqlid. In fact, Imam al-Ghazali is saying, in the above quotation, that for the layman, following the opinion of the jurist is wajib or obligatory. This is the hukum for the layman, that is, one who is not a mujtahid himself. If the person is a mujtahid, it is obligatory on him to follow his own opinion. Some jurists exclude some more cases from the meaning of condemned taqlid on the basis of the principle of necessity. The founder of the Maliki school, Malik ibn Anas, is said to have permitted 14 cases of taqlid. A few of these that fall outside the legal domain are given below. It is permitted for the layman to accept the opinion of a doctor. It is permitted to accept the opinion of a trader in the valuation of property as an expert. The buyer is allowed to accept the opinion of the butcher that the meat he is buying has been properly slaughtered. And the statement of a child bringing permission to the guest at the door that he is allowed to enter may be accepted by the guest. This shows that taqlid is a part of our daily lives, and we are indulging in some form of taqlid at each step. The truth of this claim is driven home when we examine our modern legal system. As compared to ijtihad, the purpose of taqlid is to lay down a methodology for the jurist for discovering and applying the law in the light of the already settled law. This is the function of the modern judge too, who discovers the law from the statutes and precedents to settle the disputes brought to him. It is not the task of the judge to legislate or lay down new law in his judgments. Does the modern judge perform taqlid too? The Constitution of Pakistan deems taqlid obligatory in Articles 189 and 201. These articles make the judgments of the Supreme Court binding on all courts and the judgments of the high courts binding on courts subordinate to them. The doctrines of precedent and stare decisis are nothing more than institutionalized forms of taqlid. When the lower courts follow the opinions of the higher courts, they are undertaking taqlid. In addition to this, laymen accept the opinions of lawyers in their daily legal problems. Likewise, the courts accept the statements of witnesses, unless their veracity is challenged and they are impeached. The opinions of experts are accepted in a host of other matters. The conclusion we may draw from this is that taqlid is an essential principle of our daily lives and is based upon division of labor, where some persons specialize in certain areas and become experts. The mufti or the jurist is an expert in his area, and there should be no hesitation in accepting his opinion by those who are laymen in his field of specialization. Taqlid, as generally understood, means following the opinion of the schools of Islamic law in matters of conduct. Thus, a Hanafi follows the opinion of the Hanafi school, while a Shafi'i follows the opinion of the Shafi'i school. As opposed to this, Ijtihad means that the person in need of an opinion does not follow the opinion of any school, but derives the rule of conduct for himself directly by interpreting the sources of Islamic law. Such a person would obviously be designated as a Mujtahid, and the Mujtahid must have some basic qualifications. Further, mujtahid must follow a system of interpretation, either an established system of a school or one that he has devised for himself, which will mean a new school. All persons who cannot lay claim to the status of a mujtahid due to the lack of requisite qualifications and skills must follow the opinion of some mujtahid. That is, they must perform taqlid. It is obligatory. The reason for this is that in the writings of some of the earlier jurists, taqlid is considered mandatory for all jurists, and independent ijtihad is not permitted. The cause, among others, was falling standards and the lack of ability to undertake ijtihad. This is also termed as the closing of the gates of ijtihad. There have been many discussions on this issue in modern fiqh literature, probably started by scholars like Rashid Rida of Egypt. In the light of these discussions, many modern scholars maintain that the doors of ijtihad were never closed, and this activity should be carried on in the modern world, and taqlid should be shunned. Do these scholars mean that every layman should interpret the sources of Islamic law for himself and should avoid following the opinions of the schools of law? Obviously not. Do they mean that some scholars should undertake ijtihad and the rest should follow their opinions? This would be proper taqlid if they are following a mujtahid, but the problem is that there are no mujtahid today. In reality, many scholars have adopted this course without the requisite qualifications, especially the Islamic televangelists. This is leading to the violation of the doctrine of taqlid. There are three ways in which taqlid has been, or is being, violated in the present times. To understand this, we must understand that the doctrine of taqlid, in reality, requires following the approved view of a school of law. Taqlid of the individual jurist, or taqlid shakhsi, as it is sometimes called, is not relevant. Thus, the law stated within the Hanafi school, for example, is the law approved by the school and stated in its authentic manuals. A violation of taqlid occurs when the approved law of the school is not followed. The first form of violation of this taqlid occurs when the layman jurist or modern scholar starts comparing the views of different jurists within the school on an issue in an attempt to choose one of the views. In doing so, the modern scholar is still operating within the school. The first example of such violation occurred when the famous text called the Majallah ignored the view of the Hanafi school and constructed a document on the basis of random selection of views from within the school. The Majallah also wrecked the structure that the jurists of the school had given to the field of legal maxims, or qawaid fiqhiyah. There is another form of violation of taqlid too, in which a layman scholar does not follow one school, but chooses whichever opinion he likes from one of the schools. Thus, a scholar may choose an opinion from the Hanafi school today, and tomorrow he may choose one from the Shafi'i school or from some other school for that matter. Is this taqlid or ijtihad, or is it something else? This form goes under the name of takhyir, or pick and choose. Various methods called taqlid are covered under this. There is nothing wrong with an individual following opinions from different schools in order to seek ease. But for a layman jurist or a scholar who wishes others to follow him, this amounts to following one's whims. The reason why it is the following of whims is that the person has no expertise or skill to choose or approve opinions within schools. If he is a mujtahid, it is binding on him to follow his own opinion and not the selected opinions of the schools, as that will amount to blind taqlid. The individual too must move to the other school completely. That is, the school whose opinion he has chosen for ease and facility. A third and final form of violation is not to follow any school at all and pretend that one is a mujtahid of some kind who is qualified to express opinions. If he is truly a mujtahid, then there is nothing wrong with doing so. As the issue of whether he is truly a mujtahid is related to the topic of the obligation of following a single school, we shall not pursue it in this video.